Welcome once again to Lehto's Law. Here's Steve Lehto.
Whole bunch of people sent me a story from the San Diego Union Tribune by Alex Riggins, where an Oceanside woman was ticketed at a protest. She's now asking the Supreme Court to decide if horn honking is protected speech because she thinks it is. And here's the thing. Your right of free speech is enshrined in the First Amendment to the Constitution. And the Supreme Court has said that there are things that are not spoken that can be speech, a form of expression, okay? And so you can understand that horn honking might be. Now, I can think of an example where it wouldn't be. Best example I can think of is I have a car alarm on my car that honks the horn when somebody messes with the car. And I decide to park my car next to somebody else's house and I go on vacation. And I'm in another country and somebody messes with my car and the horn starts honking just endlessly. So somebody comes by and has the car towed as a nuisance, and I come back from vacation and go, no, that was free speech. You're stifling my free speech. Well, number one, it wasn't me honking, it was the car. Number two, what message would I have been sending other than get away from my car? So the Oceanside woman ticketed for honking her car horn during a 2017 protest outside Representative Darrell Iss's Vista office has asked the U.S. Supreme Court to hear her case and rule that horn honking is free speech protected by the First Amendment. Since 2018, her attorneys have been trying to overturn a California law that prohibits drivers from honking their horns for any reason other than warning of imminent danger. So you're driving down the street, you're out in the middle of nowhere, you see your friend, you honk your horn, you wave. Technically speaking, that would be illegal under this law. A district judge and an appeals court have ruled against her, but she has now filed a petition with the Supreme Court asking them to review this case. Using a car's horn to express support for a protest is a widespread form of First Amendment protected activity that has a history virtually as long as that of the automobile. The petition to the Supreme Court begins. Porter was ticketed for an infraction by the sheriff's deputy as she honked her horn while leaving one of the then weekly protests outside the rep's office in Vista, where community members, frustrated with the support of the president, vented their outrage and decried proposals such as ending the Affordable Care Act, dismantling environmental regulations, and building a border wall. Now, I have to return to the statement that this is about as old as the automobile itself. Believe it or not, I've written articles about histories of cars, and one of the cars that they claim was the first to have a horn in the steering wheel, as opposed to the auga horn you get over here, may have been a device called a bi-auto-go, which looks kind of like an old steampunk motorcycle on steroids that had outriggers on it so it wouldn't tip over. But it was an automobile of some sort, had such a horn. And of course, those kinds of debates rage endlessly. So I'm not going to get into that, but I just remember that was one of the vehicles that made that claim. So the American Civil Liberties Union of San Diego filed suit on her behalf the next year in federal court, arguing that California's law against honking for any reason except to warn of danger violates the First Amendment. District judge ruled against Porter, as did a 3-judge panel from the Ninth. Her petition to have the case reheard by an en banc panel was denied, leaving the Supreme Court as her final option. Meanwhile, a partner at the law firm, an associate of the firm who work for her, are the lead attorneys in the case. They said that while the honking issue might seem narrow, it has wider implications for how governments must craft laws that potentially infringe on speech rights with a scalpel, not a sledgehammer. And so if you go to a court and say, my constitutional rights are being infringed here, and you say it's one of the important ones, like, speech or religion, it's true that they might be able to pass a law that governs that. But the courts have said you've got to be extremely careful and tailor the statute to not go overly broad on this. And so I can imagine situations where I can honk my horn to express an opinion, and it's not an emergency, but it ain't going to hurt anybody. And so I can also tell you that for years, if you see people picketing, like workers picketing at a factory, it's not uncommon for people to drive by and honk their horns in support of the people picketing. Now, I've never heard of anybody being arrested for that, but then again, I don't think we've got a law similar to California's here, at least not as explicitly. It turns out that during the most recent presidential election, both candidates at one time or another urged or referenced honking as a way to support them. Honk if you support me. The pandemic showed that when restrictions are placed on gatherings, people use cars as extensions of themselves to add their voice to whatever cause they support, wrote one of the attorneys. The attorneys also argued in their petition a government witness in the case could not point to a single traffic crash in California history caused by non-warning honking. It's an overly broad prohibition. And so I don't know about that argument, because I don't think they're saying that you honk your horn will cause an accident. I think they're saying if you honk your horn, it's a nuisance. And again, I can think of examples where you'd agree with that. I drive up your driveway at 3 o'clock in the morning. You don't know who I am. And I lay on the horn. And you come outside and you go, dude, what are you doing? I go, I'm expressing myself. The government defendants in this case have the opportunity to respond to the petition before the Supreme Court will decide whether to hear the case. If the court did hear the case, it'd be the second San Diego area case dealing with the First Amendment to make it to the court this term. The justices heard arguments recently in two cases dealing with the question of whether public officials can block people from their social media accounts. I am reminded, of course, about the various cases out there about people who make gestures involving one finger towards a police officer. And in the old days, if you did that, you might often get arrested, certainly pulled over and harassed, probably get a ticket. And courts have overwhelmingly said that doing that's a form of speech. Again, it's not spoken. It's not even necessarily verbal. But it is an expression of an opinion or an idea. And that's protected, one would think, by the First Amendment. Now, as an attorney, would I advise you to every single time you see somebody that you do that just to express yourself? I don't know. As a society, we probably don't want people just walking around doing that all day long. Among other reasons, it would lose its impact. If you flip them all off, it's no longer an insult. So there you go. But we'll see what happens here. But right now, they've asked the court to take the case up. The court has not ruled on that yet, but they could. And if they do take the case up, the Supreme Court could decide whether or not honking your horn is a form of protected speech under the First Amendment. Questions or comments, put them below. Otherwise, talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Most people work just hard enough not to get fired and get paid just enough money not to quit.